Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Muldrow v. City of St. Louis. In this case, the court considered this issue. Does Title VII of the Civil Rights Act of 1964 prohibit discrimination in transfer decisions, absent a separate court determination that the transfer decision caused a signification disadvantage? The case was decided on April 17, 2024. The Supreme Court held that an employee challenging a job transfer under Title VII must show that the transfer brought about some harm with respect to an identifiable term or condition of employment, but that harm need not be significant. Although the judgment vacating and remanding the case was unanimous, Justice Elena Kagan authored the majority opinion of the court, which was joined by 5 other justices. Nothing in Title VII's text requires a transferred employee to show that the harm they suffered was significant. Rather, as long as the transfer left the employee worse off in some way with respect to their employment terms or conditions, and was made because of a protected characteristic like sex or race, it violates Title VII's prohibition on discrimination. There is no basis for reading a heightened significant harm standard into the statute. Title VII targets employment practices that treat a person worse because of a protected trait, without distinguishing between significant and less significant harms. While concerns about frivolous lawsuits are valid, courts have other ways to dismiss meritless claims without imposing an extra textual significant harm requirement. Justice Clarence Thomas authored an opinion concurring in the judgment, suggesting that the majority misinterpreted the opinion by the U.S. Court of Appeals for the Eighth Circuit. Below, Justice Thomas argued that the appeals court's language requiring a tangible change in working conditions that produces a material employment disadvantage is not a heightened harm requirement. Justice Samuel Alito authored an opinion concurring in the judgment, criticizing the majority for failing to clarify the degree of harm required under Title VII, arguing that there is little if any substantive difference between the terminology the court approves and the terminology it doesn't like. Justice Brett Kavanaugh authored an opinion concurring in the judgment, arguing that while he agrees with the majority in rejecting the significant employment disadvantage requirement, he disagrees with its new standard requiring some harm. Justice Kavanaugh provided an example of a situation that clearly violates Title VII but may not satisfy the majority's some harm requirement. We are transferring you to the Cincinnati office because you are black, but your compensation will not change. Any transfer on a discriminatory basis, no matter how quantifiable the harm, should be a violation of Title VII. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kagan delivered the opinion of the court. Sergeant Jatanya Claiborne Muldrow maintains that her employer, the St. Louis Police Department, transferred her from one job to another because she is a woman. She sued the city of St. Louis under Title VII, alleging that she had suffered sex discrimination with respect to the terms or conditions of her employment. The courts below rejected the claim on the ground that the transfer did not cause Muldrow a significant employment disadvantage. Other courts have used similar standards in addressing Title VII suits arising from job transfers. Today we disapprove that approach. Although an employee must show some harm from a forced transfer to prevail in a Title VII suit, she need not show that the injury satisfies a significance test. Title VII's text nowhere establishes that high bar. From 2008 through 2017, Sergeant Muldrow worked as a plainclothes officer in the St. Louis Police Department's Specialized Intelligence Division. During her tenure there, she investigated public corruption and human trafficking cases, oversaw the gang unit, and served as head of the gun crimes unit. By virtue of her division position, Muldrow was also deputized as a task force officer with the Federal Bureau of Investigation, a status granting her, among other things, FBI credentials, an unmarked take-home vehicle, and the authority to pursue investigations outside St. Louis. In 2017, the outgoing commander of the Intelligence Division told her newly appointed successor that Muldrow was a workhorse still more, that if there was one sergeant he could count on in the division, it was Muldrow. But the new Intelligence Division commander, Captain Michael Deba, instead asked the department to transfer Muldrow out of the unit. Deba wanted to replace Muldrow, whom he sometimes called Mrs. rather than the customary sergeant, with a male police officer. That officer, Deba later testified, seemed a better fit for the division's very dangerous work. The department approved the transfer against Muldrow's wishes. It reassigned her to a uniform job in the department's 5th District. While Muldrow's rank and pay remained the same in the new position, her responsibilities, perks, and schedule did not. Instead of working with high-ranking officials on the departmental priorities lodged in the Intelligence Division, Muldrow now supervised the day-to-day activities of neighborhood patrol officers. Her new duties included approving their arrests, reviewing their reports, and handling other administrative matters. She also did some patrol work herself. Because she no longer served in the Intelligence Division, she lost her FBI status and the car that came with it. And the change of jobs made Muldrow's work week less regular. She had worked a traditional Monday through Friday week in the Intelligence Division. Now she was placed on a rotating schedule that often involved weekend shifts. Muldrow brought this Title VII suit to challenge the transfer. Her complaint alleged that the city, in ousting her from the Intelligence Division, had discriminated against her based on sex with respect to the terms or conditions of her employment. In later deposition testimony, Muldrow set out her view of what the transfer had cost her. She had been moved out of a premier position in the police department into a less prestigious and more administrative uniformed role. She had fewer opportunities to work on important investigations, as well as to network with commanding officers. And she lost material benefits, her weekday work schedule and take-home car. Or, as she summarized the situation, I went from straight days, weekends off with a take-home car and more visibility and responsibility within the department to a rotating schedule with few weekends off, assigned to uniformed patrol, with responsibilities being limited to that of administrative work and supervising officers on patrol. Title VII, Muldrow asserted in her suit, prevented the city from making those changes to her employment because of her sex. The district court, viewing the matter differently, granted the city summary judgment. Under circuit precedent, the court explained, Muldrow needed to show that her transfer affected a significant change in working conditions producing material employment disadvantage. And Muldrow, the court held, could not meet that heightened injury standard. She experienced no change in salary or rank. Her loss of the networking opportunities available in intelligence was immaterial, because she had not provided evidence that it had harmed her career prospects. And given her continued supervisory role, she had not suffered a significant alteration to her work responsibilities. Finally, the district court concluded that the switch to a rotating schedule, including weekend work, and the loss of a take-home vehicle could not fill the gap. Although mentioning those changes in her statement of facts, Muldrow had not relied on them in her argument against summary judgment. And anyway, the court stated, they appear to be minor alterations of employment, rather than material harms. The Court of Appeals for the Eighth Circuit affirmed. It agreed that Muldrow had to, but could not, show that the transfer caused a materially significant disadvantage. Like the district court, the Eighth Circuit emphasized that the transfer did not result in a diminution to her title, salary, or benefits. And the circuit, too, maintained that the change in her job responsibilities was insufficient to support a Title VII claim. In the Fifth District, the court reasoned, Muldrow still had a supervisory role and participated in investigating serious crimes. So the court thought Muldrow's view of the new job, more administrative and less prestigious, was unsupported by record evidence and not persuasive. The court did not address Muldrow's new schedule or her loss of a car, apparently thinking those matters either forfeited or too slight to mention. Overall, the court held, Muldrow's claim could not proceed because she had experienced only minor changes in working conditions. We granted certiorari to resolve a circuit split over whether an employee challenging a transfer under Title VII must meet a heightened threshold of harm, be it dubbed significant, serious, or something similar. We now vacate the judgment below because the text of Title VII imposes no such requirement. Title VII makes it unlawful for an employer to fail or refuse to hire or to discharge any individual, or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment, because of such individual's race, color, religion, sex, or national origin. Muldrow's suit, as described above, alleges that she was transferred to a lesser position because she is a woman. That transfer, as both parties agree, implicated terms and conditions of Muldrow's employment, changing nothing less than the what, where, and when of her police work. So the statutory language applicable to this case prohibits discriminating against an individual with respect to the terms or conditions of employment because of that individual's sex. That language requires Muldrow to show that the transfer brought about some disadvantageous change in an employment term or condition. The words discriminate against, we have explained, refer to differences in treatment that injure employees. Or, otherwise said, the statute targets practices that treat a person worse because of sex or other protected trait. And in the typical transfer case, that worse treatment must be with respect to employment terms or conditions. The terms or conditions phrase, we have made clear, is not used in the narrow contractual sense. It covers more than the economic or tangible. Still, the phrase circumscribes the injuries that can give rise to a suit like this one. To make out a Title VII discrimination claim, a transferee must show some harm respecting an identifiable term or condition of employment. What the transferee does not have to show, according to the relevant text, is that the harm incurred was significant, or serious, or substantial, or any similar adjective suggesting that the disadvantage to the employee must exceed a heightened bar. Discriminate against means treat worse, here based on sex, but neither that phrase nor any other says anything about how much worse. There is nothing in the provision to distinguish, as the courts below did, between transfers causing significant disadvantages and transfers causing not so significant ones. And there is nothing to otherwise establish an elevated threshold of harm. To demand significance is to add words, and significant words, as it were, to the statute Congress enacted. It is to impose a new requirement on a Title VII claimant, so that the law as applied demands something more of her than the law as written. And that difference can make a real difference for complaining transferees. Many forced transfers leave workers worse off respecting employment terms or conditions. After all, a transfer is not usually forced when it leaves the employee better off. But now add another question: whether the harm is significant. As appellate decisions reveal, the answers can lie in the eye of the beholder, and can disregard varied kinds of disadvantage. Take just a few examples from the case law. An engineering technician is assigned to work at a new job site, specifically, a 14 by 22-foot wind tunnel. A court rules that the transfer does not have a significant detrimental effect. A shipping worker is required to take a position involving only nighttime work. A court decides that the assignment does not constitute a significant change in employment. And a school principal is forced into a non-school-based administrative role supervising fewer employees. A court again finds the change in job duties not significant. All those employees suffered some injury in employment terms or conditions, allegedly because of race or sex. Their claims were rejected solely because courts rewrote Title VII, compelling workers to make a showing that the statutory text does not require. The city, in defense of that added requirement, makes three main arguments: one about the text, one about our precedent, and one about policy. None justifies the use of a significant standard. The textual claim invokes the ad justum generis canon, the idea that a general phrase following an enumeration of things should be read to encompass only things of the same basic kind. Recall the prohibition at issue here: an employer may not, based on sex, fail or refuse to hire or discharge any person or otherwise, discriminate against her with respect to her compensation, terms, conditions, or privileges of employment. Refusing to hire or discharging a person, the city notes, causes a significant disadvantage, so the subsequent otherwise phrase, the city claims, can apply only to things causing an equal level of harm. But the city fails to explain why the presence of significant disadvantage must be part of the list's common denominator. The text itself provides a different shared trait. Each kind of prohibited discrimination occurs by way of an employment action, whether pertaining to hiring, or firing, or compensating, or, as here, altering terms or conditions through a transfer. That is a more than sufficient basis to unite the provision's several parts and avoid ad justum generis problems. There is no need for courts to introduce a significant harm requirement. The city's argument from precedent fares no better. It relies on a case which addressed Title VII's separate anti-retaliation provision. Under that section, an employer may not take action against an employee for bringing or aiding a Title VII charge. The court held that the provision applies only when the retaliatory action is materially adverse, meaning that it causes significant harm. The city thinks we should import the same standard into the anti-discrimination provision at issue. But that would create a mismatch. The precedent adopted the standard for reasons peculiar to the retaliation context. The test was meant to capture those, and only those, employer actions serious enough to dissuade a reasonable worker from making or supporting a charge of discrimination. If an action causes less serious harm, the court reasoned, it will not deter Title VII enforcement. And if it will not deter Title VII enforcement, it falls outside the purposes of the ban on retaliation. But no such, frankly extra-textual, reasoning is applicable to the discrimination bar. Whether an action causes significant enough harm to deter any employee conduct is there beside the point. The case itself noted the difference. The anti-discrimination provision, we explained, simply seeks a workplace where individuals are not discriminated against because of traits like race and sex. The provision thus flatly prevents injury to individuals based on status, without distinguishing between significant and less significant harms. Finally, the city's policy objections cannot override Title VII as text. In the city's view, a significant injury requirement is needed to prevent transferred employees from swamping courts and employers with insubstantial lawsuits requiring burdensome discovery and trials. But there is reason to doubt that the floodgates will open in the way feared. As we have explained, the anti-discrimination provision at issue requires that the employee show some injury. It requires that the injury asserted concern the terms or conditions of her employment. Perhaps most notably, it requires that the employer have acted for discriminatory reasons, because of sex or race or other protected trait. And in addressing that issue, a court may consider whether a less harmful act is, in a given context, less suggestive of intentional discrimination. So courts retain multiple ways to dispose of meritless Title VII claims challenging transfer decisions. But even supposing the city's worst predictions come true, that would be the result of the statute Congress drafted. As we noted in another Title VII decision, we will not add words to the law to achieve what some employers might think a desirable result. Had Congress wanted to limit liability for job transfers to those causing a significant disadvantage, it could have done so. By contrast, this court does not get to make that judgment. In light of everything said above, the Court of Appeal's treatment of Muldrow's suit cannot survive. The court required Muldrow to show that the allegedly discriminatory transfer out of the Intelligence Division produced a significant employment disadvantage. As we have explained, that is the wrong standard. Muldrow need show only some injury respecting her employment terms or conditions. The transfer must have left her worse off, but need not have left her significantly so. And Muldrow's allegations, if properly preserved and supported, meet that test with room to spare. Recall her principal allegations. She was moved from a plainclothes job in a prestigious specialized division, giving her substantial responsibility over priority investigations and frequent opportunity to work with police commanders. She was moved to a uniformed job supervising one district's patrol officers, in which she was less involved in high-visibility matters and primarily performed administrative work. Her schedule became less regular, often requiring her to work weekends, and she lost her take-home car. If those allegations are proved, she was left worse off several times over. It does not matter, as the courts below thought, and Justice Thomas echoes, that her rank and pay remain the same, or that she still could advance to other jobs. Title VII prohibits making a transfer, based on sex, with the consequences Muldrow described. We recognize, however, that the decisions below may have rested in part on issues of forfeiture and proof. The district court noted, for example, that Muldrow had failed to discuss in her argument against summary judgment the changes in her work schedule and vehicle access, and perhaps following that lead, the Court of Appeals did not address those harms. In addition, both courts suggested that some of the allegations Muldrow made about the nature of the work she did in her old and new jobs lacked adequate evidentiary support. We leave such matters for the courts below to address. All we require is that they use the proper Title VII standard, and not demand that Muldrow demonstrate her transfer caused significant harm. We accordingly vacate the judgment of the Court of Appeals for the Eighth Circuit, and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Thomas, concurring in the judgment. I agree with Justice Alito that the Courts of Appeals all appear to articulate the same principle, but with slightly varying verbal formulations. A plaintiff bringing a claim under 42 U.S.C. Section 2000 E2A, 1, must show harm that is more than trifling. And, there is little practical difference between that principle and the Court's holding. I am not convinced, however, that the Court accurately characterizes the Eighth Circuit's decision. I do not read the Eighth Circuit to have necessarily imposed a heightened harm requirement in the form of a significance test. The Eighth Circuit defined an adverse employment action as a tangible change in working conditions that produces a material employment disadvantage. It further explained that minor changes in duties or working conditions, even unpalatable or unwelcome ones, which cause no materially significant disadvantage, do not rise to the level of an adverse employment action. In other words, a plaintiff must have suffered an actual disadvantage as compared to minor changes, i.e., more than a trifling harm. That standard aligns with the Court's observation that a plaintiff must show some disadvantageous change in an employment term or condition. The Court insists that the Eighth Circuit must have demanded more given the weight of Muldrow's allegations. Specifically, the Court underscores Muldrow's claims that the City of St. Louis moved her from a plainclothes job in a prestigious, specialized division, with a take-home car and a regular schedule, to a uniformed job supervising one district's patrol officers, with no take-home car and an irregular schedule. But most of those allegations are forfeited or attributable to a non-party, the Federal Bureau of Investigation. Before the Eighth Circuit, Muldrow argued only that the city moved her to a job that was more administrative and less prestigious. Her only evidence in support of that argument was her own deposition testimony, which neither the District Court nor the Eighth Circuit found persuasive. And Muldrow's testimony certainly did not establish any proof of harm resulting from her reassignment. After the transfer, Muldrow's pay and rank remained the same. She was given a supervisory role, and she was responsible for investigating violent crimes, such as homicides and robberies. Muldrow even conceded that the transfer did not harm her future career prospects. At most then, Muldrow expressed a mere preference for one position over the other. Muldrow failed to prove that there was any non-trifling change in her job's prestige, which was her lone theory of harm. The Eighth Circuit rejected Muldrow's adverse employment action claim accordingly. I fail to see how the Eighth Circuit's reasoning, that a plaintiff must offer colorable evidence of harm, is equivalent to the heightened harm requirement the Court concludes the Eighth Circuit applied. All that said, I recognize that the terms material and significant can but do not always imply a heightened harm requirement. Although I find it unlikely, it is possible that the Eighth Circuit had such a stringent test in mind when it stated that a plaintiff must show a materially significant disadvantage. I thus agree to vacate and remand to the extent the Eighth Circuit's analysis is inconsistent with a more than trifling harm requirement. Justice Alito, concurring in the judgment. I agree with the judgment in this case, assuming without deciding that all the facts mentioned by the Court are relevant and properly presented. Petitioner's transfer altered the terms or conditions of her employment, and therefore she can prevail if she can prove that she was transferred because of her sex. I do not join the Court's unhelpful opinion. For decades, dozens of lower court judges, with a wealth of experience handling Title VII cases, have held that not every unwanted employment experience affects an employee's terms or conditions of employment. The lower courts have used various verbal formulations to express this point, and the court, dubious about the words they had selected, granted review to provide guidance. Now, after briefing and argument, that guidance is as follows. Title VII plaintiffs must show that the event they challenge constituted a harm or injury, but that the event need not be significant or substantial. I have no idea what this means, and I can just imagine how this guidance will be greeted by lower court judges. The primary definition of harm is physical or mental damage, and an injury is defined as an act that damages, harms, or hurts, an unjust or undeserved infliction of suffering or harm. These definitions incorporate at least some degree of significance or substantiality. We do not typically say that we were harmed or injured by every unwanted experience. What would we think if a friend said, "I was harmed because the supermarket had run out of my favorite brand of peanut butter," or "I was injured because I ran into 3 rather than the usual 2 red lights on the way home from work"? I see little if any substantive difference between the terminology the court approves and the terminology it doesn't like. The predictable result of today's decision is that careful lower court judges will mind the words they use, but will continue to do pretty much just what they have done for years. Justice Kavanaugh, concurring in the judgment. Title VII of the Civil Rights Act of 1964 makes it unlawful for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. The question presented in this case is whether transferring an employee, for example, changing an employee's job responsibilities or job location, on the basis of race, color, religion, sex, or national origin violates Title VII. The answer is yes. I therefore agree with the straightforward opinion jointly authored by Judge Tatel and Judge Ginsburg for the en banc D.C. Circuit. As that court explained, even when a transfer does not change an employee's compensation, a transfer does change the employee's terms, conditions, or privileges of employment. Therefore, a transfer made on the basis of the employee's race, color, religion, sex, or national origin violates Title VII. As I see it, and as the D.C. Circuit saw it, the issue here is not complicated. Suppose that an employer says to an employee in the Columbus office, "We are transferring you to the Cincinnati office because you are black, but your compensation will not change." Does that violate Title VII? Of course it does. To begin with, the employer has treated the employee differently because of race. To be sure, the fact that a transfer may not involve a change in compensation can affect the amount of any damages, as Muldrow's attorney acknowledged. But a transfer changes the terms, conditions, or privileges of employment. Therefore, a discriminatory transfer violates the statute. The plain text of Title VII requires no more. Unlike the D.C. Circuit, some courts of appeals have held that discriminatory transfers are not prohibited by Title VII unless the transfer also causes significant employment disadvantage. Today, this court definitively rejects those rulings. I fully agree with the court on that point. But the court's opinion then goes on to require that a plaintiff in a discriminatory transfer case show at least some harm beyond the harm of being transferred on the basis of race, color, religion, sex, or national origin. I disagree with the court's new some harm requirement. No court has adopted a some harm requirement, and no party or amicus advocated that requirement to this court. More to the point, the text of Title VII does not require a separate showing of some harm. The discrimination is harm. The only question then is whether the relevant employment action changes the compensation, terms, conditions, or privileges of employment. A transfer does so. Therefore, as the D.C. Circuit explained, a transfer on the basis of race, color, religion, sex, or national origin is actionable under Title VII. All of that said, the court's new some harm requirement appears to be a relatively low bar. Importantly, the court emphasizes that some harm is less than significant harm, serious harm, or substantial harm. Therefore, anyone who has been transferred because of race, color, religion, sex, or national origin should easily be able to show some additional harm, whether in money, time, satisfaction, schedule, convenience, commuting costs or time, prestige, status, career prospects, interest level, perks, professional relationships, networking opportunities, effects on family obligations, or the like. So even though I respectfully disagree with the court's new some harm requirement, I expect that the court's approach and my preferred approach will land in the same place and lead to the same result in 99 out of 100 discriminatory transfer cases, if not in all 100. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.